Here's the problem with Uber and Lyft. Because they keep on stiffing riders and stiffing drivers, the anger builds up on the rider side, the anger builds up on the driver side, and we do things, right? We organize strikes, we organize protests, we out them in the media. What do riders do? They're bringing in bills. They're bringing in bills. So all this money at the end of the day, just because they don't want to comply, just because they want to stiff the people, they pay the price at the end. They pay even more. It's a lose-lose situation for these companies. New Jersey couple's legal fight with Uber inspires Bill to fight deceptive practices. There it is, the word deceptive practices from day one. Even under Travis Kalanick, even more under Darryl Koshashawi and David Risher. Deceptive practices, stealing, wage theft, deceptive practices. Do you see the pattern here in the media? These words appear every single day. They cannot get out of that wheel. Why? Because they don't know how to play the ethical game. It's very simple. A state Senate panel unanimously advanced a bill Monday that would place restrictions on contracts private companies enter into with their customers. Legislation the bill sponsors said would limit deceptive practices that cause people to unwittingly sign away their rights. The measure was inspired in part by the plight of Georgia and John McGinty, who were in a serious car crash while riding in Uber in March 2022. The state appellate court ruled in October that the Princeton couple's lawsuit against Uber cannot be heard by a jury because they agreed to a ride-hail giant's terms and conditions, which include an arbitration provision requiring most disputes to be handled privately. The McGinty's, who were left with serious injuries, including spine and rib fractures, have said their 12-year-old daughter is the one who agreed to Uber's terms and conditions when she used Uber Eats to order a pizza months before the crash. The appellate court's ruling says Georgia McGinty herself agreed to Uber's terms when she first signed up for the app in 2015. The ordering of a pizza should not waive your right to a trial if you are injured in a personal injury suit in a car accident months later, Georgia McGinty told lawmakers on the Senate Commerce Committee's Monday. The McGinty's told senators on the panel about their drawn-out legal challenges against Uber, which they engaged in while recovering from the injuries and facing financial challenges. They said they didn't understand what arbitration really meant until they went through this nightmare. The bill approved by the committee would limit consumer contracts solely to the service offered by the company and purchased by the consumer. Bill sponsor Senate President Nicholas Scutari, D-Union, said a statement it would stop companies from engaging in some deceptive practices. Ambiguous, all-encompassing consumer contracts put customers at risk and could leave them with no protections when seeking assistance for service problems. Alex Daniel of the New Jersey Civil Institute argued against the bill Monday, suggesting that it would limit arbitration. He also said the legislation could be struck down by a court under the Constitution's Supremacy Clause, which says that federal laws take precedence over state laws. That struck a nerve with some senators who admitted they don't read the terms and conditions of every app they use. Senator Joe Cryan said he found Daniel's argument repulsive. Are you saying that states should just sit by when someone signs off on terms and conditions through a 12-year-old to get an Uber Eats delivery? Their family is destroyed, critically injured, and goes through all of that. And are you saying based on the Supremacy Clause, we're all just supposed to sit there and say, oh, well, too bad? Senator John Bramnick, our union, pressed Daniel if any of the Institute's clients are insurance companies. Daniel said he'd have to check. Bramnick said he wants to make sure that when people sign up for the services like Uber, they don't release all their rights to a third-party arbiter. I heard your answers. I think it's cold and calculated, said Bramnick. Adam Letterman, president of the New Jersey Association for Justice, supports the bill. Terms of services are increasingly opaque, and this bill would right the wrong. If you contract with one arm of the company, it won't apply to other services provided by the company. He added that the McGuinty's case brought this legislation to the legislator's doorstep, and he called passing the bill a common sense solution to protecting New Jersey consumers. I want to see where this bill goes, right? Let's give it power. Let's just give it energy and share this video, right? The McGuinty's are hoping to take their case to the state Supreme Court and also help educate the public on how arbitration can hurt their legal challenges against powerful companies with a mountain of resources. We really are on a very slippery time when everything now, all these apps have the click-throughs that people are not reading, they're not looking at, Georgia McGuinty said. And it's becoming a very slippery slope, and we need to start protecting the consumer. Asked to comment, Uber spokesman Austin Radcliffe said judges in the McGuinty case noted Georgia McGuinty agreed to the company's terms of use on multiple occasions. It's also important to note that in addition, that's why every time, my friends, you opt out, right? Multiple occasions, multiple opt-outs. This channel keeps you informed of all the upgrades on terms of service. Each and every single time you have to opt out. It's also important to note that in addition to existing legal avenues, Uber maintains a 1.5 million auto liability policy as required under New Jersey law, which is 50 times the coverage available to the passenger in a typical car in New Jersey, and the highest of any state in the country, Radcliffe said. So I'm super happy that this couple is bringing the bill. Whatever we can do to support you, whatever we can do to put the pressure on legislators and politicians to take action, because it's just BS. It's BS the way they con the rider, the way they con the driver with their updates. And then if something happens, you don't have legal recourse. I happened to opt out from day one with Uber and Lyft. That's why I sued Uber for $900,000. That's why I sued Lyft for $600,000. Uber has already settled with me. And Lyft, I'm pressing them to settle with me. I'm going to whip them until they pay up. And the McGuinty's are doing this by exposing the deceptive practices. Our job is to keep on exposing the deceptive practices of Uber, Lyft, DoorDash, and all these gig companies. And we have to be relentless in our efforts. So keep on exposing, my friends. Keep on exposing. God bless you all.